90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. My special guest is attorney Marco Brown, and he's a well-known matrimonial attorney, but he's practicing in Utah, and he's also put together ideas about how to properly bill and effectively bill and to get paid for your work, which is important to all lawyers in every field of law. And Marco, welcome to Law You Should Know, and thank you for sharing your wisdom and experience. How do lawyers need to change their mindset about money and getting paid?
Yeah, this is really important. So we're taught early on in our careers by law professors and whatnot that doing good is our job. It is not. Providing for ourselves and our families is our number one job. And we need to realize that the contract we have with our clients is we do excellent work for them. We need to be masters of our domain. You do excellent work for them, and they pay us 100% for the work we do. That is the contract. If your clients are not paying you 100% for the work they do, they are stealing money from you, no different than them stealing money from your own pocket, which you would never allow, but you somehow justify it to yourself that they just shouldn't have to pay you everything that for the work that you've actually done for them. That's the mindset shift that has to happen.
And also, you're not going to be able to pay your bills. You're not going to be able to pay your employees. You're not going to be able to pay your rent or your mortgage and other things you need in life, and that
exactly.
you've earned. So it's a question of survival. You have to pay your bills.
Exactly.
And your employees and your rent and everything else, or your mortgage.
Yep. If you want your employees to hate you, don't get paid 100% because you're screwing them. You're stealing from them. And
they're working hard for you, and you want to reward them accordingly.
Yep.
So in terms of frequency of billing, you yourself, you're in the matrimonial law field, and terms may differ in other fields of law. Is it important to bill regularly?
Absolutely. So when I first started out, I started from zero here in Utah in 2010. No network, no nothing. I was scared to send out invoices, so I'd send them out every 2, 3, 4 months. No, you have to send them out at least once a month, okay? And do it on the first, whatever day it is, just do it. But it has to be very close to the first of the month, at least once a month. You can do it more often than that if you want. I have friends that will do it every week or every other week. Doesn't work for me, but you have to do it at least once a month.
And how detailed should that bill be?
I do itemized billing. So I don't do block billing. I don't like block billing. Here in Utah, block billing doesn't really comport with our fee affidavit. So we should be doing line item billing for every time entry.
And it sounds better to a client. If you had to do 10 steps in order to produce something, you're kind of breaking down the steps for them. And it's harder for them. It's easier for them to understand. And if you have to prove your work in court, it's much easier to understand. Or maybe in a matrimonial, you're recouping fees from the other side. So you're showing the components of your bill.
Yeah, exactly. I don't like block billing. I understand why people do it, but I think it's too easy to hide the fact that you haven't really done anything in there, right? I don't.
And a judge or another lawyer or client might say it's ridiculous, 10 hours to research something.
I had a case, guy charged $100,000 on a motion to enforce, said he billed 3 hours a day. I think it was 3 hours a day for like 4 calendar months or some such thing, right? But it was all block billing. And I told him, I looked over the affidavit and I'm like, absolutely not. You need to itemize all of this so I can look at it. And, he got 90 some odd % of it written written off by the judge because of what he did, because of how he billed.
And in matrimonial law and perhaps other fields, it's important to get an adequate retainer up front so you avoid billing and collection problems?
Yeah, absolutely. This is one of the biggest things. So you need to get a larger retainer, whatever that is, and I can go over how to figure that out, but you need to get a larger retainer, and then you need to re-up the retainer every month. Okay, so it doesn't get down to zero and below zero, because when it gets below zero, you're a banker. You're not a lawyer. Don't be a banker. You're not good at that. Just be a lawyer, right? So do that every single month, and that's going to solve humongous amounts of problems.
And that's the main one is going to avoid collection problems and ongoing work that needs to be done. So if you have exactly. That pool of billing or that pool of fees, and as you said, as it gets lower, you want it replenished. So it's full like a gas tank. So it's full at all times.
Yep, that is exactly what I say to my clients. It's like a gas tank. Car full, car goes.
And also, you'll do a better job on a full tank of gas or fees.
Yep. You want to hate your client and do bad work for them, have them owe you $5,000.
And you don't want the car to run out of gas because it's not going to help the matter progress. Are there any other tips or thoughts you have about that? About the fees, the billing, getting the money up front?
Yeah, you have to. What you have to do is you have to create a system in which you stop work if they don't pay you or they don't re-up on their retainer. Okay, so it has to be a well thought out system, and you cannot run the system as the attorney. Attorneys can never run the system. They suck at it. They're terrible. So it has to be somebody else, and that has to be that person's number one job. So if you have a paralegal and you want to put him or her in charge of this system, fine, but that has to be their number one job. Okay, they can do stuff for you after. They can answer the phones. They can do whatever, but they have to collect as their number one job.
And maybe there's a day of the week or a time of day that they're focused on that.
Yep. My office manager does this for me, and she has taken the entire day today on the 20th is when we run credit cards. That's the only thing she does. She will do that today, and then tomorrow she will follow up with them.
So is a credit card a good way to get that advanced retainer and replenish it?
I think that's the easiest way to do it, yes.
And what if the client has limited means? Do you sometimes take less from certain clients in advance so it's manageable to them? Do you ask them to get money from a parent or friend or relative?
I don't care where they get the money. I care that they get the money. So I do not discount anything. If you're discounting something, you're going to get in trouble. You're chasing money at that point. That is not going to work out well for you as the attorney. If you cannot get sufficient retainer out of people for the work you do, then you have a sales problem. You are not valuing yourself and valuing your time and what you do correctly, and then communicating that value to people in such a way that they want to pay you. That's a sales and closing problem, and that's something that you need to work on.
And just like clients may have to qualify for a mortgage or qualify for a loan, should you qualify them financially before you accept them as a client?
I don't do that because I figure that the credit card company has done that. So some bank somewhere has done that analysis, and I don't do that analysis. I'm a divorce attorney. I don't want to do that. So like the credit card people do that.
And so you basically rely on that, and you'll take the credit card, and that kind of systems work for you, and you think that's a very good way to go for attorneys, especially matrimonial attorneys.
Yeah, I think that 95% of my people pay with credit cards. I believe that is a fine way to do it. There are other funding mechanisms that you can utilize, and if you want to do that, you want to figure those out, that's totally fine. I've just never really had to.
Judging that initial retainer, how do you calculate that?
Yeah, so quickly, what you want to do is in an ideal world, you want to take your absolute worst month, and that's your retainer. Okay, so everything goes wrong, that is your retainer. That's almost impossible to get, though, and I realize that. So what you do is you back that down to like your 95th percent worst month. Okay, and that's a much more manageable number for people. So whatever that is that $4,000, is that $5,000? In my realm, that's kind of where it is. And so you back it down, you look at your data, you figure out that number, boom, that becomes your retainer.
And if there's a period that not much is happening in that case, that that pool will still be full, and they won't owe you much for that. But you alert them that the case is coming up for trial or for a hearing or for deposition. So
yes,
be ready for that expense.
Yep, exactly. We communicate that. When it comes to trial, we go to trial on about 1% of our cases because we get stuff done out here and through mediation. But when we do get close to trial, then we tell them, hey, look, there's going to be a trial retainer, and a trial retainer is, ours is like $10,000 a day. So we're telling them that months in advance so they can get that together and get that to us before the last pretrial.
Okay. And you mentioned mediation, and I'd like to discuss that with you in a moment. I'd just like to mention again that we're talking with Marco Brown. He's a well-known matrimonial attorney, and he's based in Utah, but he's also given a lot of thought to the billing process and to have it make sense for the lawyer and for the client, and so that the lawyer gets paid for the work that they're doing on behalf of the client. So, and you're listening to Law You Should Know here on 90.3 WHPC, the voice of Ness Community College in Garden City, Long Island, New York. If you missed any part of this program, it's available at nccradio.org. And Marco, you mentioned that as a matrimonial attorney, you sometimes get involved with mediation. How does that work, and do you feel that's a win-win situation for everyone, and it keeps the legal fee under control?
Yeah. Here in Utah, we have a culture of mediation. And like I said, about 99% of our cases get done through mediation. I think it's fantastic. I wish all states would make a big push for it. But many of them still have that litigation model, which I think hurts kids more than anybody else. And then it's very costly and emotionally costly and, monetarily everything. So I wish we would go toward that mediation model. I love it. That's where we go with almost all of our cases at the very beginning. The only time that it doesn't really work is if somebody has a psychosis of some sort and it's just not going to function, or there's a real disparity, domestic violence sort of situation, sexual violence, whatever, serious emotional violence, and there's such a power disparity that not even the lawyers can overcome it, right? It doesn't work in that situation. So there are a couple situations it doesn't, but for the vast majority of cases, it does.
And in the mediation model that you're following, is each party represented by their own attorney?
Yes.
And who's providing the mediation? Is it the court? Is it an outside mediator? Is it someone else?
Many states will provide somebody through the court system. In Utah, we do not have that. We have private mediators. So there's a robust market for private mediators out there, and we just use them and figure out which ones work best on which types of cases, and then we engage them.
And is there usually any problem in getting your clients to come on board? I'm thinking of the clients on both sides, or agreeing on a particular mediator?
No, we don't allow our clients to dictate which mediators we use.
Okay. And how long does that mediation process take? Is it a couple of sessions? Is it like how many hours in front of the mediator does it involve?
Average successful mediation here in Utah, at least in our law firm under our data, is about 6 hours, and we almost always get it done in one session of mediation. Maybe there's 10 to 20% where we go back for a second session.
But that mediation session for that case lasts about 6 hours.
Yeah, successful mediation session will last about 6 hours.
But it's much quicker and simpler than being in court for days or weeks and going back and forth.
Yeah, it'll be going through mediation will be probably a fifth to a sixth the cost of going through full litigation.
And at what point does the mediation take place? Is it early on before discovery, before formal discovery, which can also be drawn out and expensive? Is it before trial or?
Yes, always before trial. Sometimes multiple times before trial if it's ordered that way. There are initial disclosures, especially financial disclosures, that have to happen in Utah. So it happens after the initial financial disclosures, which happens at the very beginning of the case, but usually within 3 to 6 months of the beginning of the case.
And so you avoid other expensive court conferences or motion practice and even depositions to some extent because you have the paperwork there?
Exactly. Exactly. So our data is about 85% of our cases go straight to mediation and never see the inside of the courtroom.
And are most clients satisfied with that? They figure they're meeting their goal and they're keeping their expenses under control?
Yes, we explain that to them. We explain why we do it. We show them the numbers, and then they get to negotiate. They're actually in there negotiating, figuring out what their life looks like, instead of somebody in a black robe telling them what their life looks like. And that person in the black robe will never care about them again and never think about them again. So they're almost always more satisfied with mediation than they are trial and litigation.
And that person in the black robe usually doesn't want to hear their story. That's not their job.
Yeah, they don't care.
So in the mediation process, in those 6 hours, and I realize you're an expert on it and you've been through this many times before, what is the process? Does the mediator speak to each side separately? Do they try to work on some issues at a time and caucus separately with you and your client and go back and forth?
The way we do it, it's almost always a caucus. We almost always just start separate. Sometimes we start together, but the vast majority of the time we just start separate. And then the mediator caucuses, right? Goes back and forth and facilitates communication. Whether or not we start with the big hard issues or the little issues depends on the case and how we feel the progression we feel our client needs to go through. So usually we'll start with the easier stuff and kind of build up to the harder stuff, right? Because you want to get that momentum going toward negotiation.
And goodwill, so to speak.
Yep, exactly. But sometimes we just know that there is one thing that has to get done, and then the dam will break on everything else. And sometimes we just tell the mediator, look, we got to deal with this one thing, and then we can deal with everything else. And that's the sticky wicket. And
you're having that private conversation with the mediator so they know what issues they need to mediate first, and which will be more complicated for them.
Yes.
And there's some give and take. I mean, there may be certain issues that are important and deal breakers to you and your client, and others that are important to the other side. And there has to be a little flexibility on both sides.
Yep. We always tell our clients, look, you're going to feel like you took it a little bit, and the other side is going to feel the same way. That's just the way it is. So if you both feel that way, it's probably been fairly successful as a mediation.
And do you feel that mediator being there act as a buffer? It's more effective than if you would have negotiations directly with the other attorney, and what sometimes in New York they call a four-way with both attorneys and both clients involved, that it's important to have that mediator as the facilitator, as the, running the show and being the tough guy or bad guy if it comes down to it.
Exactly. So I've done that where I've just done straight negotiation with the other side and we all get together. But what I found is it's much more effective to have a mediator there, because the mediator can be the bad guy, but it can also be the person who looks at the case from a somewhat objective point of view and gives you creative solutions that you hadn't thought of before.
To both sides, what they think might work. If you give a little on that, they can give a little on this. Rough justice. Yep. And the attorneys are satisfied, and the clients on both sides are satisfied at the outcome. It's divorce, right? It's managing a train wreck. So no one's super satisfied with everything. But what I can tell you is my experience, people going through the full-scale litigation process and then going through mediation wins hands down almost always. And of course, a client and a lawyer, for that matter, has no control over the outcome of litigation. You don't know what the judge will do, which way they'll go. And, you could be stuck with a bad situation. It could be a temporary victory. It's going to be expensive either way. The mediation, the mediator will listen, and then they'll give feedback, and they'll try to bring the parties closer one step at a time. Yeah, that's exactly right. I'm a good divorce lawyer. I have lost only about 1.5 trials in my time, but I remember the one I lost like nothing else. I should not have lost that case, and it pained me for a long time. I thought I had it in the bag, and the judge just went another way, right? So you never know what's going to happen. And there can be problems with evidence, with proof, with hunches, with hidden income, with proving different things. So with the mediation, the mediator has a lot of flexibility. Yeah, and the other nice thing about the mediation
mediation is it never comes out in the open, right? It's confidential. It's completely confidential. So if you have a client that you are just scared to death of putting that client on the stand, you can get things done in mediation, right? But even for clients that would otherwise be absolutely awful during trial.
And a client might get themselves in trouble if there's undocumented income, if there's other questionable expenses, maybe for a business or personal dealings. As you said, what goes on in court might be public and it might get out there, or a judge may get mad about something. With the mediation, it's private.
Yeah, exactly. I don't know how many times we have had people that lied on their taxes and we have had to deal with that in mediation, but we can deal with it in mediation and we can ensure that they do not get reported to the IRS, and we cannot ensure that if that comes out during a trial.
We're talking to Marco Brown. As you can tell, he's a very experienced matrimonial lawyer in his home state of Utah. He's also given a lot of thought to billing and what billing works for the attorneys, and it's fair to the clients, and he's sharing his insight with us today. And you're listening to Law You Should Know here on 90.3 WHPC Radio. If you missed any portion of the program and you want to tell someone else about it, it's nccradio.org is the site for our podcast of this and many other shows about the law. What if, in the rare experience that the client challenges your bill or the lawyer's bill, should the lawyer talk as an advocate for their bill, explain in greater detail what went into the work and the experience that's going into it and the professional service the clients received, and hopefully the good result as well?
Yeah, absolutely. You should be able to defend your bill, because if you can't defend your bill and show that you've done excellent work, then you suck as a lawyer, right? So you should be able to do that. What I suggest people do is when a client comes back and they say, oh my goodness, this bill is huge, you say, okay, I understand that. We're expensive. What I want you to do is I want you to tell me exactly what you disagree with. So and that's another line item advantage, right? Like, tell me the line item you disagree with and we will discuss it. You will come into the office, we will sit down, we will talk about it. 95% of the time, they just pay the bill and they never talk about it again.
At the end, they're more or less satisfied because you're always explaining to them how much you've saved them, and how much they're able to, go on with their lives. It's not so easy after a divorce. You're cutting the pie in half, but you're finding a way they can do that and move on with their life and move ahead of the divorce or beyond the divorce.
Exactly. When we meet with people and we tell them our price and they balk at our price, we will very often say things like, hey, look, you have a house, you have retirement, you have this, you have that, we have alimony and child support we need to deal with, and you have 4 kids, right? We have a lot of kids out here in Utah. So you got 4 or 5, 6 kids, whatever it is, right? What we're going to charge you is a $10,000, $15,000, $20,000. That's a pittance compared to the amount of money that we're talking about, and it's absolutely a pittance compared to your kids and how valuable your kids are, right? And we just keep reminding them about that throughout the process.
And it's also their future, because if it doesn't work out, they could be losing a future of their earnings, a future of their wealth. They could be giving up half their wealth now and a lot of their future earnings. So you're a protector. You're putting a shield and a force field around that and preventing that from happening or minimizing it to some extent.
That is exactly correct. And when I say that if you are not able to get from your clients the retainer that you want, it's a sales and a closing problem. And this is exactly what I'm talking about. You need to be able to communicate the value in what you do and be very, very upfront and forceful about it. Because the work you do, the work we do as matrimonial attorneys, the work we all do as attorneys is incredibly valuable to our clients. And we need to be able to communicate that clearly and forcefully to them.
And this is something like a nuclear bomb going off now. And if it's not managed properly, it's going to adversely affect them for the rest of their lives. And you're protecting them from an adverse result.
That is exactly correct. So criminal defense attorneys, they have this exact sort of sales ability in their pocket as well. Like, Like, this is the worst. This is potentially the worst thing that's ever going to happen to you your entire life. And you're going to pay me to fix it the best I can. Same kind of thing in divorce, right? This is probably the second worst thing that's ever going to happen to you in your life. And you're going to make an investment to ensure that the rest of your life is taken care of.
And it may go on, the consequences may go on longer than the jail term and exactly. Psychological as well.
Yep. It's decades this goes on.
How do you manage their expectations from an initial, consultation to going before the mediation to during the mediation?
So we communicate with our clients all the time. We communicate with them systemically, right? At least once a week, usually multiple times a week. We call them, we do all these things. And when we do that, we are managing their expectations. So it starts in the consult. We are not used car salesmen. We do not give guarantees. We don't do that sort of stuff. We say, this is the process we're going to go through. We're going to protect you. We're going to do everything we possibly can. This is our kind of best estimate. But, we're not exactly sure. So we have to go through the process. But we tell them that, right? I don't know how many clients I've lost to other attorneys who are just charlatans and will say whatever and promise them the moon. And they go hire those people. Totally fine. I don't want those clients. I want to manage expectations. I want people that know and understand that we're going to do the best we can, but we can't guarantee anything for them.
And at least with the mediation process, there are some guardrails. If they go into litigation, it could be an explosion. There could be a big disaster at any time, depending on that judge, depending on what facts come out.
That is exactly
so. It
right.
Could be a wreck. You're gonna keep them from a wreck situation.
Yeah, Andre Agassi used to say, you can't predict crazy, right? And litigation is crazy.
And what about the child custody? That is also under the laws in your state, that can all be worked out within certain limits through the mediation process?
Yeah, my joke is that unless you sell your children into slavery, you can come to whatever agreement you want on your kids.
But I'm saying there is more flexibility. There are more tools available. There's more give and take. Visitation, things can all be worked out among the parties.
Yep, absolutely. So we sit there, and this is what we spend most of our time on in mediation, actually, is figuring out the kids, right? Because people don't fight about money nearly as much as they fight about their kids, because their kids are so much more important. So yes, we can get together, we can create nuanced plans, all of these, crazy schedules if we need to, so on and so forth. And judges are just not going to do that. They're going to take a meat cleaver to these people's lives and split this crap in half and say, whatever, like, deal with it, right? But in mediation, you can use a scalpel, and that's what we do.
And that mediator is used to working with the scalpel and carving out arrangements that work for both parties.
Exactly. Yes, that's why we pay them. That's why we pay them good money.
Marco, do you want to give us a website where people can contact you, or perhaps you have other ideas there about handling divorce cases or ideas helpful to lawyers?
Yeah, you can go to our main website. It's www.brownfamilylaw.com. So that's our main website. I also produce a lot of YouTube videos explaining things. Also, I'm on TikTok at Divorce Attorney on TikTok. YouTube, you just go in there, search Marco Brown or Brown Family Law, and you get a ton of my content that way.
Okay. Any other final thoughts that you want to give lawyers out there who are trying to manage their clients or appropriately bill their clients in a divorce?
Let me tell you my story very, very quickly. So from 2010 to about 2016, I was very bad at all of this stuff. And I led a bad life. I led a life that was very difficult. I let myself get fat. My spiritual walk was bad. My family situation was not great. And then I decided to change and to get paid 100% for the work I did, and then use that money to solve problems. Okay. So if you do that, if you make that switch, your life is going to get so much better than you could possibly imagine right now. Your stress is going to go down. You're going to be able to pay your people what they should. You're going to be able to pay yourself and your family and spend less time at your job. If you run a bad shop as a lawyer, run a bad law firm, your life is going to suck, right? Because you spend 10, 12 hours a day running a bad shop. That is not conducive to a good life. Please run a good shop. Get paid 100% for the work you do.
Okay. I would like to thank Marco Brown, attorney, as you've heard, a very successful matrimonial attorney, and who's given a lot of thought to client billing and expectations. And you can contact him at brownfamilylaw.com for being our guest on Law You Should Know. And if you missed any portion of this program or you want to tell someone else about it, go to nccradio.org for a copy of the podcast. And please join us here on 90.3 WHPC, the voice of Nassau Community College, for another program on Law You Should Know next week at this same time.